I used to work with someone, he had been in claims for like 30 years, and he would say, putting a price on people's misery. That's what we do here. What he was really saying is damages are central to the claims process. It's central to the reserving, to the authority request, to how you're going to handle something.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
So this is a preamble to the social inflation episode you're about to hear with Sherry Belitz. She's amazing and gives a ton of really great information explaining social inflation. I'm doing this preamble because I want you to, when you listen to it, think how this is going to change post-COVID-19. A lot of what she talks about is an underlying trust and deception that is driving these social inflation settlements and verdicts. And I wonder how COVID will change that. You see a lot of corporate entities and structures stepping up, doing the right things, putting people over profits. Will that impact the jury pool? So give this a listen. We're going to do a follow-up after the dust kind of clears a little bit on COVID-19 and bring Sherry back and talk to her. But when you listen to this episode, keep that in mind. Hey, everybody. Welcome back to The Defense Never Rests. I am your host, Trisha Baxter, and today we are doing a deep dive into social inflation and nuclear verdicts. Joining me is a co-host today, back by popular demand, Scott Ribney. Hey, Scott, how are you?
I'm good. How you doing, Trish?
I'm good. So before we get into the episode and I introduced our guest today, I just want to say, if you like what we're doing, we would super appreciate you subscribing on whatever podcast channel you're listening to. Give us a comment, a like, a review. We super appreciate it. We also have a YouTube channel. It's called The Legal Navigator. Hit us up there if you prefer YouTube. But we super appreciate any support that you can give us. So without further ado, we have today an awesome guest. She has so much knowledge in this brain of hers, and I can't wait to pick her brain. She is an attorney turned sort of an expert on jury consultant. She works for Blueprint Trial Consulting. Sherry Belitz. Sherry, hey, welcome. How are you?
Hi, Trish. Hi, Scott. How are you? Thanks for having me.
Welcome aboard.
Awesome. So when we've talked about this episode a couple times, and I've picked your brain a little bit, but I've stayed away from it on purpose because I really wanted to be as surprised by what you said today as our guest. But let's first talk about what is social inflation. It's actually been around a while, but it's gotten a lot more attention in the past several years. Sherry, how would you define it to those who have never heard of it?
Sure. So social inflation, that term has really come into vogue a lot lately, but it was actually coined back in 2010 in an insurance publication white paper. If you're interested, Google Partner Re. It's a very interesting white paper about social inflation. And now the term kind of gets used always in conjunction with nuclear verdicts, but nuclear verdicts were actually just one aspect of social inflation, and that's what the insurance industry seems to be concentrating on these days.
So do you see, in your expertise, do you see a rise in the nuclear verdicts or the social inflation, or is it more the media fake news kind of thing?
No, we absolutely see a rise, and we've done the research too. So it's easy to look at the media and we see the talc verdicts, 4.7 billion, kind of shocks the conscience. We've seen those pesticide verdicts. We see, if you look at Law 360 on a daily basis, you will see very large verdicts, but it's also in the more mundane cases, the trucking cases we see all the time, med mal verdicts. It's really across the board. So we have seen the aggregate verdicts really go on a trajectory since about 2009. So this is a phenomenon of the last 10 years.
What is at the heart of this phenomenon or the increase in the phenomenon?
Okay, well, if you're prepared to hear me talk for a little while, I've kind of outlined the 4 points. I call it the big four, and this is based upon my research and my company's research. So we have 4 big categories that are driving the nuclear verdicts. The first is the cultural zeitgeist, or what I like to call the spirit of the times. So we start out with the premise that there is always an inherent bias against the corporate defendant by the time they walk into a courtroom. It's just that David Goliath sort of little man against this big conglomerate, faceless corporation. That's the inherent bias. However, that has been exacerbated, by something I like to call our evolving jury. And our evolving jury is, so say 20 years ago, 15 years ago, our juries were comprised of predominantly baby boomers, predominantly Generation X, like myself, like you. And now we are starting to see more and more millennials on our jury, and Generation Z has just come of age and they are joining our jury pool. So they're getting more packed with Generation Z each year. So the cultural zeitgeist is one. I don't know if you want to delve deeper into that, or you want me to kind of tick off the other big four reasons.
Yeah, tick off the four. I'm actually, of course, I don't have a pen with me. I was going to write them down, but tick off the other four, and then let's go back and break down the ones.
Okay, sure. So the second reason, and this should absolutely not be discounted, I actually think this is probably more significant than the millennials on the jury, but it is the absolute increasingly creative, increasingly resourceful plaintiff's bar and what the plaintiff's bar is doing. And they are doing a phenomenal job. They are a formidable opponent. They are sharing their resources. They are sharing their playbooks. And this is not something that's unusual. This is actually, think about it. They're based on a referral-based model. They are not going to get repeat business, you hope, from someone who's injured. They operate on a very collaborative model where defense lawyers operate on a competitive model. So there's really not the incentive of sharing information like there is with the plaintiff's bar. So they have formed groups. They are sharing resources like nobody's business. Second, they have become increasingly astute regarding social psychology. We saw that with the reptile theory in 2009. Verdicts just started rising after that, and that's when we started seeing the term social inflation, nuclear verdict. So they were using social psychology as a different way to approach jurors and talk to them with a focus on arousing anger and arousing fear instead of arousing sympathy, which is kind of the old school way to present cases. So you have the reptile theory. You have something that I've done a lot of research in graduate school, and it goes way back. It's called the anchoring bias. Plaintiffs are taking the anchoring bias, which is an old social psychology concept. And I remember reading an article, and it was in the 90s, and it was called, "If you want to get something, ask for it. The more you ask for, the more you get." This was a 1996 article by social psychologists, and that's just what plaintiffs' lawyers are doing. They are setting the bar high. They are asking for big verdicts. They are asking for large settlements. So that is really an underpinning of social psychology. And then the two other things they are doing, and they really are intertwined, is they are using third-party funding to fund all of the jury research, all of the mock trials, all of the focus groups. And this third-party funding, it's basically financiers investing in their cases and taking a cut of the verdict or the settlement. So you have this injection, this influx of money, and that is funding your jury research. There was a lawyer, a plaintiff's lawyer, quoted in Above the Law, and he said, "I have research facilities in my office. My basement is basically where we run our mock trials," and they're mocking all of their cases, not just their $20 million cases. They're mocking auto cases, and they have the funding to do it. So those are two kind of inextricably intertwined aspects of the plaintiff's bar's resourcefulness.
So tons to unpack on that. You have such
Tons.
great knowledge. Let's go back to the first one that you talk about,
Sure.
which is the kind of the big bad company, the trust factor. Because I think most people would say, yes, the big bad company reputation has deteriorated over the decades. You know, Johnson & Johnson, with that recent $8 billion award, it was reduced, but it was in the 60s, 70s, 80s, a reputable company seen as the epitome of corporate responsibility. And look where they are now. Is that what you're talking about as far as the decline in a trust situation?
Well, I think that's an interesting question, and there's a couple ways that I would go about answering it. There's a couple of aspects. So, with our evolving jury, with the millennials, you have to remember, and people say it so negatively, the millennials or the Generation Z, but really think about the times that they came of age. They came of age, and I can give you the big two here is in a time of less corporate dependence and a time of greater corporate distrust. And those factors, the less corporate dependence is, of course, based on our gig economy, buying goods and services from third-party platforms. That's going to lead to less dependence and less trust is because some of these historical events that have happened during their formative years, you had 9/11, the financial crisis, Occupy Wall Street, all sorts of different historical events, which really sowed the seeds for corporate distrust.
Hey, Sherry, can I ask a real quick question here and jump
Sure.
in? And maybe this is starting to show my age here a little bit, but how are those events that you just relayed different from, let's say, those baby boomers who went through other events in our history, like the Vietnam War, the oil crises, various stock market crashes as a result of different companies that, one could argue put that same level of distrust in governments and businesses and corporations?
I'm so glad you asked that question. And it's actually when I started doing the research, I asked my mom the same exact question because she is the quintessential baby boomer who was born in 1949. And I realized it's only anecdotal, but they were very anti-establishment. And that was sort of the spirit of the times at the time in the late 60s, early 70s. However, you didn't have all of the information that we have now. We have a 24-hour information cycle. We have social media. Sometimes I'm getting information about the news on social media before I'm even getting it from CNN or a news outlet because it is just, it's viral. It is literally viral. So we also have more information about what are CEOs making? What kind of corporate profits are there? What are the ways that corporations are engaging in deception? And I think ultimately, and I'm not a sociologist, but I think ultimately when the baby boomers came of age, a lot of them actually became very company loyal corporate people. You don't really see a lot of Bernie Sanders aside, you probably do not see a lot of real aging hippies. I can say for one, my parents were big activists and then, became company people later on. So I think, will it happen to the millennials? I don't know, but this is the times that we're in. But I think that's an excellent question.
How do you counterbalance that as a company or defense counsel in litigation? How do you, if they're coming into that with that mindset, can you overcome that? Can you get that trust back?
I think you can to an extent. And again, we come to jury duty or we come to anything we do in our lives with our worldviews, with our experiences. Can we be completely fair? Can we be completely neutral? Absolutely not, because our experiences and our worldviews color things. But what I can do is tell you some techniques and some strategies that have helped when you talk about trust. how do you gain back trust? Well, first, I'd like to say if you have a case, and what I've noticed from my research is cases which have a theme of corporate deception are highly correlated with nuclear verdicts. So if you have a case with corporate deception, there is going to be a high correlation with the nuclear verdict. And if you look back at some of the talc cases, you look back at the pesticide cases, there were absolutely allegations of corporate deception. Opioids, that's all that was about, was deceptive marketing practices. So that is one hurdle to overcome. Another, just putting that out there, because I want to let you know if you have a case with corporate deception, and some of us have worked with this a long time. I used to handle asbestos litigation, and in asbestos litigation, there were bad company documents everywhere. There were those documents, if you've lived a good life through asbestos, you should die through asbestos. It's okay if you die through asbestos. There were some really damning company documents in the asbestos litigations. So corporate deception, nothing new, but I want to point out that there's a high correlation with deception and verdicts. People don't want to be deceived. But moving on, there are ways to ameliorate and to also personalize that corporate defendant or that company defendant. And that really starts with your theme of the case. So people have joked around with me and they said, Sherry, how are we going to personalize an opioid manufacturer? How are we going to personalize a company like Amazon or a pesticide company? And kind of jokingly, like just off the top of my head, I like to say things like, this is a company that strives to make people's pain go away. This is a company that makes products to help put food on the table. This is a company that wants to make literacy available to all. So this is, yes, a very tongue-in-cheek explanation, but why I do it is to show that there are really two sides. And by personalizing that corporate defendant, and I want to give you a great story here because this really just showed me personally. So my husband and I went to see a show recently, the Lehman Trilogy. It was about Lehman Brothers, very long show, and I was kind of not that into seeing it. I didn't want to hear more about the financial crisis, the market crash. It was kind of too depressing. But we went to the show and I was pleasantly surprised because the show wasn't about that at all. It was about the humble beginnings of the three Lehman brothers and how they came over, a really wonderful American dream story, came over from Bavaria to work in the textile business and how they built this huge business. And it made it about the American dream and it personalized it. And yes, it was a bit sanitized, but that's really the point. And it just resonated with me that all of these companies have a story, a mission, a value, a story, something they want to do well. So that I think is one huge aspect in trust and really just explaining who they are.
Yeah, and I think, let me just jump in here and then I'll let you take it, Scott. I think that's such an important note. I'm going to pull that nugget out specifically because I couldn't agree with you more. I think it's always been important for defense counsel to tell their story, their client's story, but even more so now. Most big companies have their why defined, what they do, what they're selling, and not just services, but a feeling or whatever it may be. And you need to learn that as their counsel and develop that from day one in your pleadings, in your questions. All of that needs to be a theme through everything. Your story can't just be something you develop after discovery. And putting up, whether you're vetting the right corporate designee with who is being prepped to talk about that, I think is so important. But I love that. I love that little nugget.
Absolutely. And you can do that. I remember reading something about the Johnson & Johnson family. I was curious. I'm from New Jersey. I wanted to know how the company started. And it was really it was a beautiful story. It was. And these stories need to be shared.
Sherry, let me ask you this. Have you seen any research with these big verdicts looking at I'm going to call it the white elephant in the room, but essentially the effectiveness of defense counsel in selecting the jury pool or developing the theme. And I asked that question because yesterday get the decision involving the Volkswagen
Sure.
out in California, and they gave punitive damages in that case to 4 plaintiffs of $25,000 each. And when you read how the case was developed, it falls right into what you were describing, but it seems to kind of go against the whole social inflation piece. And it makes me wonder, is this something that we as defense lawyers need to be doing a better job of? Because I can tell you, I struggle sometimes having the theme of the case, but that's something I work on like right out of the gates as soon as the case comes in, not when discovery's done and you're now getting ready to go into trial, or get someone like you involved to help out towards the tail end of the case.
So, okay, so the question is, have I been seeing any research with respect to how defense counsel's developing themes?
Right.
What we could do better. I mean, what we should be doing better, really.
Okay, so what we could do better is, I always say early is better, like from the time you get the pleadings, because also something I really haven't spoken about a lot that plaintiffs' attorneys are using is they're using reptilian, they're using the reptile theory, they're using reptilian concepts to frame their cases. And when you have them doing that, they start doing it as early as the pleadings, certainly in written discovery. By the time you get to your corporate witness needs to be prepared to answer those reptilian questions, because they are phrased in a tricky, very difficult way unless you're adequately prepared. So I would say, I don't know if that completely answers your question, but one aspect is that early intervention, early preparation, especially if you have a reptile case on your hands where damages just shock the conscience, you're going to want to engage in that early preparation. And then you can kind of develop your theme early, not when discovery is closed, not, I'm not saying the second that you get and answer a complaint, you should have a theory, but I think as discovery proceeds, you can start to get your theory and see what their theory is, because you never want to completely negate their theory. Like if their theory is something like I'm just being general here because I don't have a case in mind, this is a case about profits over people. You don't want your theory to be, this isn't a case about profits over people. You don't want to negate that. You don't want to acknowledge that. You want it to be something fresh. This is a case about personal responsibility. This is a case about making good choices. So early theme development, and really try to, if you have a compelling theme, anchors work like that too. If you can set that theme as an anchor, all evidence, all demonstratives, all testimony, everything is going to be filtered through that anchor. And even better yet, if your jurors are allowed to take notes, that theme may be written down and everything will be filtered through it. So did that answer your question, or do you have a follow-up?
I actually have a follow-up to that. How's the best way to test those theories as a defense lawyer before you obviously get into the courtroom? Because you pointed out the third-party funding that the plaintiff's bar has, the mock trials that they're doing. Should we on the defense side be doing more of the mock trials, or more of a, I don't want to say like a polling, so to speak, but something that we could be testing different words or buzzwords or themes with people to see how they react to it?
I think that's a great question, and I'm going to be really careful answering that because I want this to be information, not infomercial. Yeah. I mean, I could very easily say, yes, mock all your cases, focus groups everywhere, but I will say, and I differ with some consultants in this opinion. This is my personal opinion. Yes, the in-person mock trial is the gold standard. Again, if your case is maybe not worth a certain amount of money. It's maybe not an exercise that you have authority from your client. Maybe it's not exercise that will work. There are less expensive juror perception. I think actually now with this coronavirus, we're going to start to see a lot of more online mock trials, which is a less expensive, very effective way to test cases. But, and here's where I differ from a lot of consultants, if you can absolutely not, if it doesn't make sense to do a full-on mock or to even engage in any jury research, I think something is better than nothing. And people will fight me on this and say, you know what, that's not pristine. You're not going to get the perfect answer. But you know what, if I'm at a large firm and I'm trying a benzene case, I would rather, if I don't have the authority to do some formal jury research, I'd love to run that by my real estate department, who probably has no idea what benzene is, whether it's a theme, whether it's like, well, does this science make sense? Or my expert put together this, does this make sense? The exposure part of it, because I think something is better than nothing. You're not going to get a really scientific, pristine kind of analysis, but I always err on the side of, you know, sometimes you have to make decisions. We had a terrible case that there was a criminal component. We were dealing with the civil case. We couldn't do the mock trial, and they needed a mock trial, but there was a protective order. So we had to do a lesser type of service, but something was better than nothing. So whether you're running that by the real estate department because you don't have authority, or whether you're engaging in full-blown mock exercises, I think it can spark something and it can be helpful. That's my personal opinion. That's actually not Blueprint's opinion. That's mine.
I think that is valuable though, because you're right. The in-person mock is the gold standard, and the bigger companies and the bigger firms and the higher exposure cases are absolutely going to the in-person mocks. They're doing them, and they're doing a lot of them. But when you start to go down in exposure and you start to go down to companies that really watch their bottom line in indemnity and defense cost, that isn't an easy decision to make. So we've done online for that reason. It is cheaper, although I have a good client of mine who hates them because he doesn't find them very as reliable as the in-person. And he also says it's not the cost of the online that's the problem, it's the cost of the attorney prep, because we over prep everything. But so if you're not going to do the in-person, then you look at the online. And if you're not going to do the online because you have a client that's absolutely not going to pay for it, and there are many of them out there, and I get why it's not cheap, then find that third or fourth best way. I'm with you. You have to address the practical side of our industry, which is not everyone's going to pay for those services, and get creative when you have somebody that doesn't. I love that.
Absolutely. And there are, so it's funny. So a lot of people, when I'm doing my marketing and when I'm talking about my company, they say, can you send me your brochures? Can you send me what you have? And of course, I don't mind doing it, but the services are so customized to what you need. I'd rather say, okay, Patricia, how much is in your budget? What are you looking to do? Let me kind of mix and match what I do and see if we can do that. Like, to give you an example, we had a construction defect case. There wasn't a big budget, and really the issue hinged on, are there futures? Is this just for past costs, or is there a legitimate future claim? Because it was going to be a big monetary difference. And it really just boiled down to that question. And I knew there wasn't a lot to spend. So I said, you know what? Let's just focus in on that question and do a juror perception study, and let's just see what people think. Is there a future component? If there's a future component, yes, you're going to have to put up a little more money when you go mediate. Is there not a future component? Do people not buy this? Okay, great. Continue on with your strategy. So you can, if you can really narrow down what someone wants to do, what their objectives are, what their budget is, there's ways to take from this service and that service and really make it customized. Not everything has to be a full-blown mock.
Yeah, I agree with that. So let's go to your more of your second topic, which is the plaintiff's bar, right? I think this is a great point as well. The mobilization and the collaborativeness of the plaintiff's bar does, I think, far outmatch that of the defense bar. We try, but we don't have it down pat as much as the plaintiffs. I think they started earlier with the defense bar maybe a little bit behind. What can we do is there anything that we could do to collaborate more to match what they're doing?
You know what, I've given this a lot of thought, and I looked at the business models. And of course, I was at an insurance company for many years. I was 15 years in insurance claims, toxic tort claims at a company. So I've kind of seen it from that side. And there are just such fundamental differences in a business model that is referral based. Like a referral based model, everything is based on goodwill. Everything is based on collaboration. Maybe someone's great at trying a case. Maybe someone's great at working up a case. Maybe someone's great in Queens County. Maybe someone's better out of state. Like you really have a business model sort of working against you in the defense world. Not to say that there's not a lot of wonderful organizations, the DRIs, the CLMs that share information. So what I would say is, look, there's competition. There's competition for the insurance business. There's competition for the corporate business. But what I've noticed is there are some organizations where maybe someone who's not a huge competitor, maybe you're in Philadelphia and you meet someone in California, you do the same type of work, there can be a real referral synergy like that. Someone else in Philadelphia, maybe not. Like you really do have that competition model working against you. Like I think we have to be cognizant, but I do think we have to share resources as well. There's one book I recently read. It's by Bob Tyson, who is a defense lawyer, and he wanted to share his take on nuclear verdicts. And there's some great takeaways. He's out of California, and there are some excellent, there has to be collaboration at some level, but it is hard with the business model. It is difficult. I don't know any workarounds with that.
And I'll say, I think you're probably not going to get the same networking, but I find that when I have an issue and I've seen somebody already go through that issue, we'll reach out to that defense lawyer and they will share. There is, I think 90% of lawyers on the defense side want to help each other out. And I've reached out to lawyers and I said, I have this exact same issue. Can you help me out? Can you send me your research material or whatever? And they are sure. They open up their non-confidential file to me and say, all right, here. And I think that may be something worth doing is, if you're a claims professional or a lawyer that gets that complaint in and you read that complaint and it screams that this is where they're going. They're going to put up a reptilian theory or they're going to try and manipulate the social inflation issue to their advantage. You can see it in their narrative and how they're writing it. And you research the plaintiff and you say, all right, he's doing this or she's doing this. I think you can reach out to people they've gone up against or other lawyers that are facing your issues and ask them for help. I think you'll find that most people would do that. So
absolutely. I think when you kind of take it away from the exact client, like if you're competing for the same client, that's difficult. But when you make it more about the issue, like, hey, I'm going up against Mark Lanier in such and such county in Missouri, in front of such and such judge. And actually at Blueprint, we have data analytics to kind of do dossiers on adversaries. And really, that's a great way of information sharing about judges and about jurisdictions. Of course, the hellhole jurisdictions are always published and we try to follow, what's working and what's not in those jurisdictions. I remember there was a really good verdict in Philadelphia. I think it was a benzene case, maybe about a year or two ago. And everyone was kind of like, oh, wow, like what went right here? And sharing experts. So there are ways to collaborate, and I do think there's some wonderful organizations. So that's a big thing, collaboration. But again, a little bit of an uphill battle just because of the business model. That's normal.
Is it a different type of collaboration, or and do we need to define that a little differently? Where you have on the plaintiff's bar, they're collaborating not just on the experts, but really about the corporate defendants and the companies. Where maybe on the defense side, we need to tap into more of what you were talking about. What are the strategies the particular plaintiff's attorney is using in these certain types of cases? We need to collaborate better on the types of experts that they're using, sharing of transcripts with different experts where they may have positions that are going to be hard for them to reconcile in a current litigation.
We absolutely should be collaborating, and with AI and big data, it's absolutely possible. And in fact, we have a couple of tools that we use that harness big data to do that. We can see, okay, take for example, you have a plaintiff's attorney with an outrageous reputation of high verdicts, like a Mark Lanier I'm going to pick on, or just someone who is really just a fantastic plaintiff's lawyer. Well, if you take a look at the data, sometimes a pattern will emerge. And yes, they've had 10 really unbelievable verdicts, but let's look at them. In those 10 verdicts, they are all X injury. They have all used Y expert. They are all in Z county, or they are all trucking cases, or they are all med mal cases. So really a pattern will emerge once you look at more and more data. And I think that informs us. That knowledge is power.
Okay, now Sherry, let me ask you this one other follow-up question. I'm going to tap back into your insurance world life for a moment here, okay? But still knowing everything you know now, you're at that carrier and you get the big case in, whether it's the talc case, the clean air case, a benzene case, fill in the name of it. Are there types of questions that you think the carriers should be asking of their defense counsel before they assign that case to probe into a lot of these issues beyond just going on a panel list and saying, okay, you know what, this firm is up, or let's just give it over to that particular firm, to be able to counter a lot of what we're seeing now?
So a couple of things. I think that first, that's the threshold. You look at a panel list. Who am I allowed to hire in Illinois? And you kind of see what you have. And yes, there's exceptions sometimes, but you kind of see who you have on the list. And the more you get to know people, because I'm a big proponent of we hire people, not firms, especially if we're talking about trying a case. And there may be someone wonderful working up that case, and maybe they're super responsive and calling you back and all of that. But maybe a courtroom is just not the place that they're going to shine, or they're not going to connect with their jury. I'm just thinking of one particular matter I had years ago, and it was in Ohio. And we had New York counsel. They were pro-hopped in, but it really wasn't going to be a good match for the demographic. And then we ended up getting someone in who was really from Ohio, played football for Ohio State, like was a really, sometimes something like that is a factor. So what you can do on the claim side is you get to know your counsel, not just, on the phone, and do you have that report, and can you send me an email, but in person. I think the in-person is just invaluable. In fact, I had one go-to person who I knew if there was anything, I would just put her on the phone and I'd be like, get rid of this dispute, like figure it out and just work your magic, because I knew she could work her magic. And I just knew the problem was going to go away. And that came from knowing her on a more social sort of professional basis. You have to know who's going to be able to connect with people, because this business is really just about people.
Yeah, and I agree. I love that. I think, getting to know your counsel, get to know us, right? We
Yeah.
love that. We love that advice. I would also say to Scott's question, ask open-ended questions like, what are you doing across your cases on a standardized basis to help deflate the social inflation issues? Ask open-ended questions. If they come back with you with concrete, we do this in our depths, we talk to jury consultants, we have a jury consultant on staff, or whatever it may be, and you make sure you like that. It's concrete examples. Like our interrogatories have a section for this, maybe not labeled social inflation, but we've built it into everything that we've done. You should have an idea after you ask that open-ended question of your counsel whether they are thinking of these issues routinely, and it's not just an exception to the rule. Every case should go through these sort of questions and being vetted from is this going to be a problem on a nuclear verdict social inflation case? We've had that. I've had cases where I'm like, this is a problem, guys. This is a low exposure case, but this is a problem, right? And here's why. So I think that's a great question, Scott, though. I think if these claims people are having those conversations with their counsel early, they'll get some comfort and trust in that they have
And
the right people.
also, just to piggyback onto that, and it just kind of occurred to me, but something really important, and this has happened during my time in trial consulting, is you want to make sure your counsel, now I'm going to throw some psych terms around, is not experiencing confirmation bias, because that is the most detrimental kind of bias for your counsel to have. And what we like to say is falling in love with your case. Has your counsel fell in love with the case? Because think about it, from the time you get the pleadings, answering the interrogatories, depositions, you tend to really, no matter how bad your case is, you're going to fall in love with your cases and defenses. It's natural. You're living with it. It is a natural psychological phenomenon. It's called confirmation bias. By doing this, you're disregarding some of the real strengths of the other side, and you are overweighting some of your arguments and the facts of your case, which, again, not infomercial, but that's why something neutral like a focus group or a mock or perception study can really help you see, oh my God, I am really putting too much into, and I should say trial consultants get a lot of cases that follow a paradigm. They're reptilian cases. They follow a paradigm of a violent third-party act on an insured premises, very common case for a trial consultant to handle, because you have damages that are outrageous. You could have an assault or a rape or a shooting or something at a bowling alley or a hotel or, supermarket parking lot. And from a liability standpoint, a lot of these cases can be very defensible. It's negligent security, basically, and a lot of times it's very defensible, but the damages are so shocking to the conscience that a jury can't get past that, yet a defense attorney is falling in love with, well, we had cameras and we had mirrors and this guy was on security detail and we have a great case. Well, you know what? You also have a 15-year-old rape victim, or you have a 8-year-old who was shot. So the falling in love with the case, confirmation bias, is something to watch for. That's what a claims professional can watch for when they're talking to their attorney, and an attorney should think about it when giving a balanced perspective.
Sherry, what do you recommend, or what guidance would you suggest for the claims handler to have that discussion where they think their attorneys are buying into that to the detriment of the rest of the case? Because those are hard discussions to have, where your attorney's just so locked in to be able to say, well, wait a minute, I think you're missing something here. Do they go and get a coordinating counsel to kind of look over what the attorney did? Is it more of the claim representative having that hard discussion with the attorney, some combination of both, or something else completely?
That's interesting, that point about coordinating counsel. I didn't actually think of that, because what I was thinking of, and maybe this was my confirmation bias as someone who had been in the claims world for so long, and I had some great, super smart people that I worked with during my time. And I would say those people, and a lot of them did it, ask the hard questions. play devil's advocate. Say you have a horrible case, you have a sexual assault in the parking lot at a supermarket, and your counsel saying, well, we had great lighting and we had cameras, and they were trying to, tell you all the great stuff, falling in love with their case. Ask the hard questions. Well, what kind of psychiatric help is the plaintiff going for? How old is she? Is she going to have any psychological problems as far as maybe having children? Or, I mean, the really, really tough questions, like put yourself in the shoes of a plaintiff. And this is, of course, what a focus group or a mock group would do, to put themselves in the shoes, ask the hard questions, and, make your attorney think, make your attorney take the other side, tell your attorney to take the other side. And in fact, what a lot of lawyers tell me, because they will often argue both sides in a mock, or they will have someone from their firm argue one of the sides. And the ones who argue the plaintiff's side always say, I learned the most about this case. And I didn't realize this case has so many strengths and we have so many weaknesses, but you know what? Better to find that out at a mock or at a focus group and really kind of be able to craft your strategy.
That was my experience on the
Really?
couple that because I've always chosen to take the plaintiff's side when I've been in the mocks. Because of that, I wanted to I always thought that was a harder one to do. But yeah, you can really I can really push this theme. Stepping into that gave me a whole nother mindset. But I also just want to follow up with something you said too, and the question at hand, which is I think all claims adjusters should be making sure their defense counsel give them a pure exposure range, which is if plaintiff hits it out of the ballpark, what is it going to look like? Every case should have that on there. And then you can talk about the chance of that happening, but it needs to be if the plaintiff hits a home run, what's this number going to look like? And if you aren't putting in some sort of social inflation calculation, if the case calls for it, then you're doing something wrong. And if you have that analysis laid out if by your attorney early on, you can see that they have that in their head. I think that's
I think that's critical, and it's absolutely critical to talk about worst case scenario. And hand in hand with that is something, and I was going to mention, recognize the cultural zeitgeist that you're in. So a really easy example would be, a sexual harassment case. Pre-Me Too, post-Me Too. No question that's going to be different. I think everybody knows that. But also think about themes of your case, the more difficult ones. And this is something I think about a lot, actually. There's been no research done. I haven't done any research, but this is just kind of my hypothesis. So that talc verdict in St. Louis, that $4.7 billion talc verdict that just let the insurance industry, we were reeling from that. Think about that. That was on the heels of Me Too. Two totally different things, but think about what was involved in that talc verdict case. That was themes of deception against women. This is a women's cancer. We're talking about ovarian cancer was the injury. And this was on the heels of Me Too. What was Me Too about? Women finding their voices and becoming empowered as to the establishment against corporate America. So there may be some parallels. Some people may have walked into that courtroom with an anger, with a distrust, with deception on the brain. So really take a look at the cultural zeitgeist you're in, because your case may not be an apples to apples, pre-Me Too, post-Me Too. It could have something, this is toxic tort, but there may be some common themes.
Sherry, I got one question for you here, and it's one I've been getting more frequently, not necessarily from the claims folks, but from the people in underwriting and higher ups in insurance carriers. And the question is there research that, because these guys are all hard numbers and gals, that puts it into a percentage where they can say, okay, if we're trying to account for social inflation, here's the value of a sexual harassment case pre-Me Too versus post-Me Too, or any of the types of cases, we're seeing an increase by 3, 5, 10, 50% that we think is a result of this? I've tried to look into that, see if there's any research. I haven't come across any. Is that something you've seen or come
It's
across at
actually
all?
something, it's actually, again, without being too salesy about it, it is actually something we can do using big data, and kind of come up with numbers. There's also data analytics per case where we can, like say you mock a case, you have 3 deliberation panels, and each one comes out with something different. And it kind of leaves you thinking, is this a range? Is this a high low? Is this a best worst? There's an algorithm that you can put the information, the background information about the jury, you're mixing and matching and coming up with hundreds of thousands of permutations of juries, and you can break it down to a percentage. So data analytics, big data, it's been really helpful as far as litigation science and litigation consulting.
And I think that's going to get better as with every day that goes by, because there's seems to be such a focus internally in insurance companies as well, is they're collecting their own data
Yes.
and they're trying to extrapolate data points from that to see and apply it to future case handling. And I think that's going to get more refined. And that's maybe something the defense side has over the plaintiff side. I don't know what kind of data analytics they're pulling, but an insurance company that has that information at their, especially the larger ones that have that information at their fingertips, that's going to be easier for them to create an algorithm or something like that to apply to future. So AI, definitely keep an eye on that if you're not.
Yes.
Predictive analytics, I've tried to use them in my cases. They're not there yet for predicting how judges are going to handle things. There's a couple companies that do that, and we've had some cases that warranted it, and they're not there yet, but they will be. And I think beating them to the punch will be the insurance companies, and you guys are already doing it. So, I'll plug you if you guys need analytics and percentages. Reach out to Sherry; she'll guide you.
Yeah, absolutely. We've been doing it. It's quite exciting, and it's changing day by day, and it's really changing. It's making the litigation landscape very scientific. It's really making it about algorithms and about, like you said, predictions and predictive analytics.
So we have maybe like 10 or 15 minutes left, I think. So let's wrap up some final questions. And you did talk about this very early on, but I want to circle back. Are there industries that are more susceptible to the social inflation issues that you talked about, or the nuclear verdicts?
Absolutely, and there's research backing this. Any industry where a plaintiff or where a juror can put themselves in the plaintiff's shoes, where there is a safety issue. And this goes back to the reptile theory and that danger to the community prong of the reptile theory. Those are industries that are being hit particularly hard. So we're talking pharmaceutical, healthcare, trucking. They are seeing some really big verdicts. And that is, again, because jurors are seeing themselves. Because remember, the reptile theory, I look at it in 3 elements, kind of can't take the lawyer out of me, still looking at the prongs and the elements. But so reptile theory is what? 1, defendant has breached a safety rule. Defendant has violated a safety rule. 2, has put the community in danger. And 3, it is up to you, the jurors, to send a message, send a monetary message, and tell this plaintiff and potential plaintiffs and prospective plaintiffs, you cannot put my community in danger. So when you have something like the talc case, or like a pesticide case, or like a trucking case where there's allegations of negligence, that could have been anyone. That is danger to the community argument. So these fields are going to be more susceptible. Not to say I haven't seen some big IP verdicts, but really where a juror can see themselves as a plaintiff, like there but for the grace of God, kind of, I wasn't on that highway, or I didn't use that talcum powder, or I wasn't working with pesticides. That those are industries that are going to be hit and are hit.
What about like the future ones, like the gig economies? I mean, most people can imagine getting into an Uber or Lyft. So if you have a plaintiff that was, injured in an accident in a rideshare situation, or hit by your DoorDash guy, like, those things. You seeing any of that, or do you envision that being an issue later on?
I don't know if it's going to be an issue later on with nuclear verdicts per se, but it's definitely an issue. And I actually wrote an article about it. It's on our website. It is all about third-party platform liability, because you think about it, what if you buy like a baby stroller on Amazon and it's from some third-party seller and then it collapses and the baby gets hurt? What if you're renting out an Airbnb and someone comes by and you don't have good locks and they break in and shoot? So, I mean, there's any number of things that can go wrong when you're talking about selling goods or services on a third party platform. We've all heard about some of these Uber cases, and I don't see anything going nuclear per se, but I definitely think there's some interesting liability issues that the insurance community is grappling with and learning about, and it's really uncharted waters.
Yeah, I agree. And I think with, the autonomous vehicles, the cannabis industry, obviously the coronavirus, like those are
Sure.
trendy topics. Whether plaintiffs bar is able to really manipulate the social inflation issues to their advantage in those cases remains to be seen. But, well, I have one last question. How your closing thoughts, and I'll leave this kind of open-ended, but I'll just say, if you have a claims adjuster, general counsel, VP of claims listening, what would you tell them on the social inflation nuclear verdict to help them? I know it's kind of an open-ended question, but
No, sure. I think it's a great question, and I have so much respect for claims professionals, having been one and worked with such smart people who really care, and they're handling like hundreds of files. So I would say, first, early identification. Something easier said than done when you're like handling 150 files, but identify those cases that have those damages that are shocking to the conscience. I used to work with someone, he had been in claims for like 30 years, and he would say, putting a price on people's misery, that's what we do here. And he was saying it as a joke, and it was like kind of his shtick, but what he was really saying is damages are central to the claims process. It's central to the reserving, to the authority request, to how you're going to handle something. So I would say, number one, you get a file, even if it's pre-suit, look for those shocking damages, because you are going to want to intervene early, whether you're doing trial research, jury research, again, a misnomer, it's really litigation research. You are going to want to intervene early with those, see if you have a reptile on your hands. Other things that you can do is you can get counsel involved early to do the same thing, and you can, as the claims professional, ask the hard questions, because they're smart and they know what they're doing, and you want them to ask the hard questions to defeat any confirmation bias that their attorney may have. Play devil's advocate, ask the hard questions. So I would say that those are two quick fixes that you can do. Not hard. This is not full-blown research. It's just stuff that you can do in your office when you get a file in. And those are probably the two easiest.
well, great tips. I agree with you. Early. The
Absolutely.
quicker you can identify, the quicker you can address it with your defense counsel, or your supervisor, or your insured, or your client. You can have those discussions, and everybody, I think the earlier you have those discussions, then when either pre-suit or right when litigation starts, you step into that litigation with your eyes wide open. There's no surprises. And that's what we defense counsel try to do across the board, is to eliminate those surprises. We don't want you to be surprised 2 years after a lawsuit starts with, oh, this is happening, right? So great advice. Tell us what you have going on. I know you have a webinar or a speaking event coming up, but tell us what you have going on and where people can find you.
Oh, sure. Okay. Well, I just found out my speaking event was adjourned.
No, sorry. I gave you a plug.
No surprise. I think we're going to try again in June. I think we're all in a little bit of a, this is the new normal, what's going on. So I'd like to actually podcast more and do some more webinars and things like that. So that's what I'd love. You can certainly reach me via my email at sbelitz, BELITZ, at blueprinttrial, one word, .com. And, I'd be happy to answer any questions that you have from this podcast or in general. And that's probably the best way to reach me.
Yeah, I think definitely reach out to Sherry. There's so many things that I wanted to cover. I would love to have a whole episode on reptilian theory. That's been covered for over a decade. If you
Yes.
and this is, I'd love to do that. We just don't have enough time. Maybe we'll do a separate one. But
Sure.
definitely reach out to Sherry. She knows what she's talking about, and she's just a ton of fun to talk to. So, Sherry, thank you for coming on.
Thanks for having me.
And until next time, we will see you on The Defense Never Rests. See you guys.